this meeting to order of meeting number 20 of the House of Commons Standing Committee on International Trade. Today's meeting is webcast and is taking place in a hybrid format pursuant to the House Order of January 25th, 21. Before I go into the issue we're dealing with Mr. Savard Tremblay, we had said that we would deal with the two motions that you wanted to speak to. Can I make a suggestion, Mr. Savard Tremblay? Would you be okay with dealing with these two motions at the end of the meeting?
Aucun problème. Tant qu'on les traite aujourd'hui, j'ai pas de...
No problem as long as they're dealt with today.
Okay, so, all right, so pursuant to Standing Order 108 and the motion adopted by the committee on October 23rd, 2020, the committee will proceed with its study of the investor-state dispute settlement. I would now like to welcome our witnesses to this panel as individual, Gus Van Harten, Professor of Law, Osgoode Hall Law School, York University, Lawrence Herman, Counsel Herman and Associates, Mark Warner, Principal Counsel, MAAW Law, Trade Justice Network, and Angela McEwen, Co-Chair. Mr. Van Harten, you have the floor to start, please.
Thank you, Madam Chair, and good morning, everyone. I have been studying ISDS for many years, maybe 20 years, and I have some simple advice for you today. Canada should adopt a perspective of quiet determination to withdraw from its ISDS risks and costs where possible, whenever possible. So let me elaborate a little. The context, obviously, is we're in the midst of a crisis, a global pandemic. That crisis has revealed vulnerabilities and possibly limits of our era of globalization. We have lack of vaccine manufacturing capacity. We have lack of other manufacturing capacity in Canada and in North America. The electrician told me I was lucky to be able to get a breaker for my electrical panel a couple of months ago because there's only one factory producing them in North America, and it was shut down by an outbreak in the summer. Just one anecdotal example. Besides the pandemic and what it's revealed in terms of vulnerabilities, we have all kinds of complex risks coming at us, environmental challenges, climate disruption, the rising debt burdens, economic inequality, loss of jobs and businesses, and rise of political extremism. And in this context, I would suggest, not wishing to be sensationalist at all, but I would suggest we need to prepare for the prospect of some winding down or further winding down of the globalization era of the last 30 years or so. It certainly dominated my adult life, this era. I'm not sure if the winding down will be gradual or sporadic or jolting, but I think it would be wise for us to think about planning for some sort of winding down. And what that means is a shift in strategy more to a national capacity, likely with more of a North American regional orientation, as opposed to a global orientation. Global markets will still always be vitally important, but we have to have some kind of robust plan B to deal with changing circumstances and the crises yet to come, whether they are public health related, environmental, financial, economic. And to do that, we need to strengthen the regulatory maneuvering space and governmental capacity in Canada, nationally and subnationally. And to do that, we have to free ourselves from ISDS risks and costs. This is a different order of risk and cost compared to all other forms of adjudication, whether international or otherwise. There are potentially billions at risk, the huge deterrent impact on governmental decision making. I've been documenting that for years in various countries. you have ISDS creates this really difficult to justify shift in bargaining power within governmental decision making. I would say it's even leading to a kind of reconfiguration of the state, the governing apparatus of the state, in favor of foreign investors and against anyone in Canada who has a different interest on any issue. There's also long-standing issues in ISDS about this underlying taint of the process because of the extraordinary power of lawyers sitting as arbitrators to interpret vague language in the treaties in order to order retrospective damages amounts running into potentially billions of dollars against states. The process is not independent, it's not fair, it's not balanced, it's not respectful of domestic institutions. Those criticisms have been out there for a long time. Basically, in summary, with ISDS treaties, we've been writing checks that have an unknown amount on them, a blank where it says the amount, this check, it's blank, is to be determined by very wealthy foreign investors and by the lawyers and arbitrators who interpret the treaties in the event of a claim by one of those foreign investors, usually big multinational entities or billionaires. So ISDS treaties, they haven't cost us catastrophically yet. They've been very serious impacts in the context of some other countries, but I think it's just a matter of time. As we respond to challenges and crises in the future, eventually ISDS treaties are going to cost us. They're going to hamper us more, complicate and deter our efforts to protect Canadian interests. It's going to do the same. ISDS treaties will do the same to other countries too. And I think, broadly speaking, we want those other countries to have national capacity to respond to crises as well. So how should we respond? Very briefly, we need to retain and strengthen governmental capacity and flexibility and strengthen our domestic institutions based on Canadian law that protects all investors and based on the customary approach to international law in relations between states and foreign nationals, a customary approach that frankly has been departed from dramatically and at times simply mangled by ISDS arbitrators over the last 20 years or so. ISDS is the clearest and riskiest obstacle from a legal point of view to building this governmental capacity going forward. So that's why my advice is fairly simple: withdraw from ISDS. There's various ISDS reform efforts, but in summary, they're sort of scattered, painfully slow, and generally flagging or not that promising. So that's why I say develop a strategy of withdrawal from ISDS where, and however possible, we have a window to let the clock tick down on existing ISDS treaty commitments, and we should start taking advantage of it now. I'm not trying to be provocative or inflexible about how we withdraw. I would just say to prioritize it. The tactics will depend on the particular treaty in which we already have ISDS commitments. But we really need to take ourselves on this path, in my view. Very briefly, in summary, I've heard a lot of arguments for ISDS treaties. I understand what is at stake for Canadian companies operating abroad. I understand the alternatives to treaty-based ISDS are viable, but they're certainly not perfect. In my judgment, however, ISDS treaties are just not worth the national loss and future constraints in any context where we've agreed to ISDS. And so we need this attitude of quiet determination to get out and in the meantime, otherwise limit ISDS risks as best we can. Thank you.
Thank you very much, Mr. Harton. On to Mr. Herman, please.
Thank you very much. I'm very pleased to be able to present my views. Let me just say that I have followed Gus Van Harten's writings for years now. He is one of Canada's leading experts on this matter, and I have a great respect for his points of view. I'm going to approach this a little bit differently from the point of view of a former diplomat many years ago, when I used to serve in Geneva at the Canadian mission to what was then called the General Agreement on Tariffs and Trade. And I've been involved in these matters for years since. It's been a long time since I've been in government service. ISDS is a fact of life in international relations, and it is not going to disappear. And in my view, as meritorious as Professor Van Harten's points are, and they do have a lot of merit, it's going to be impossible to change the ISDS system. They're ingrained and they're built into not only trade agreements, but separate foreign investment protection agreements. There are between 2,500 and 3,000 of these agreements globally. And of course, Canada has a number of them. As the committee knows, ISDS is built into our regional trade agreements like the NAFTA, now the CUSMA. ISDS is built into the Trans-Pacific Partnership Agreement, the CPTPP. ISDS is built into the Canada-European Agreement, and it is part of bilateral trade agreements we have with Latin American and Caribbean countries, and including a bilateral trade agreement we have with South Korea. So withdrawing from ISDS, frankly, is political.
Donc se retirer du RDIE est franchement politiquement et diplomatiquement très difficile. Et c'est probablement quelque chose qui n'aura pas lieu. Alors la question, c'est que pouvons-nous faire? Je voulais signaler quelques éléments au comité.
I'm hearing French translation.
You're hearing French translation. Okay, just 1 second, Madam Clerk, if you can look into that, please.
Are you on the French channel?
I think the problem is solved. Thank you.
Thank you very much. Sorry, Mr. Herman, please resume.
That's fine. Professor Van Harten is correct. You know, ISDS was initially conceived of as a means of stabilizing the investment situation for wealthy countries, northern countries, if you like, the industrialized countries, that would help to stimulate investment flows to the developing world. That was the basic rationale, and it has morphed into a system where private enterprises, private corporations can challenge national measures for a variety of reasons. We can go into the details during the question and answer period. And by the way, I should say that if the committee wants a good review of the issues and the facts respecting ISDS, there's an excellent study done by the Canadian Centre for Policy Alternatives a couple of years ago, and I've reread it over the weekend, and it still is very pertinent. I'm not saying I agree with the Canadian Centre for Policy Alternatives in many respects, but as a review of ISDS, there isn't, I don't think, a more useful document. So I recommend that you have a look at that. There's a couple of things about ISDS that do indicate where Canada is exposed. Canada and the Canadian provinces are exposed. But one of the things I would mention is that, not widely appreciated, Canada has a bilateral investment treaty with China. It was concluded in 2012, entered into force in 2014, and it lasts for 16 years after entry into force. So it runs until 2030 with a carryover period for investors, providing them with rights for 15 years after that. The question before the committee, one question before the committee is, does that give Canadian investors practical legal rights vis-a-vis China when they invest in China? On the other hand, is Canada exposed to private investment arbitration brought by Chinese companies that have invested in Canada? That's an issue, and it's not going to go away. Now, I want to just mention the Canada-European Trade Agreement. There have been improvements in the ISDS process in the Canada-European Agreement, the CITA. I don't believe those will enter into force. The CITA is being applied provisionally. The parts of CITA on ISDS with the reforms in the system require ratification by all of the member states, and I am very skeptical that that will come about. So CITA will continue for some time without those ISDS provisions. The factor that I think has to be weighed in all of this is whether ISDS gives Canadian investors advantages, rights, certainty in their investments abroad. That's an issue that has to be examined. Now, in the Center for Policy Alternatives study, they rightly point out that most of the treaty provisions, the protective rights for investors, have been used by the Canadian mining sector, the extractive sector. But there are arbitrations going on beyond the extractive sector where Canadian investors have sought recourse to these provisions in ISDS. So there is a benefit to Canadian outbound capital that has to be considered in all of this. The final point I would make about withdrawing from ISDS is, as I indicated before, where they're embedded in our international bilateral or regional trade agreements. We can't simply withdraw from ISDS because they're embedded in our trade agreements, including the CPTPP, and if you like, the NAFTA CUSMA carrying over some of the NAFTA provisions for 3 years. So you can't just withdraw from ISDS when they're embedded in trade agreements. It is possible for Canada to abrogate its bilateral investment treaties. But one thing that has to be mentioned, and it's very important, is that investment protection treaties, our foreign investment protection agreements, contain two things. They contain rights of private investors, ISDS rights for private Canadian investors to bring binding arbitration, but they also contain important obligations of governments to respect the rights of investors. So, and that means that Canada can bring arbitration proceedings against a foreign government that doesn't give adequate protection to Canadian investors. So the state-to-state obligations in these treaties is of great value. Withdrawing from those treaties would mean that there would be no longer any binding treaty obligations between the host government abroad and Canada. So that would, in my view, limit as a policy option withdrawing from these foreign investment protection agreements. What can be done? I think that picking up on points that have been made by others, in Canada's future negotiations of foreign investment protection agreements, strong consideration should be given to not having ISDS provisions in those bilateral treaties. So that's where I would leave off. My final point is that the options, realistically speaking, are regrettably quite limited in this area. So those are my comments. I'd be happy to answer any questions.
Thank you very much, Mr. Herman. On to Mr. Warner, please.
Thank you. This is the first time I'm doing this, so thank you for the invitation. I am a Canadian lawyer, an Ontario lawyer, but I'm also a New York lawyer. And I thought that before I was a lawyer, I was an economist, and I worked for Professor Alan Rugman, who was one of the big advisors during the Canada-US Free Trade Agreement negotiations and one of the leading experts on investment. And that's really how I started out sort of thinking about investor-state dispute settlement. And I thought what I could do to try to be useful to your committee today is to try to take you through my experience with ISDS a little bit as a way of illustrating what I think are the advantages and the disadvantages and some of the things that sometimes get lost. So when I was working with Alan Rugman in the late 80s, in the lead up to the Canada-US Free Trade Agreement, Canada was coming out of a very difficult environment. We had the National Energy Program, which had led to one of the greatest outflows of capital from any country at that point in recorded history. I think it's probably still true. We had the Foreign Investment Review Agency, which was the subject of a dispute settlement proceeding in the old GATT, General Agreement on Tariffs and Trade, where Canada lost. And one of the first things that Brian Mulroney did when he got elected was to get rid of, or not to get rid of, to sort of change FIRA to make it more of a welcoming system towards investment, and then gradually to repeal the National Energy Program. Now, I say that history because I think, wearing my two hats as a Canadian lawyer and an American lawyer, I've always been struck by the Canadian version of the history of the Canada-US Free Trade Agreement tends to, I think, forget something, which is that the Americans wanted ISDS to be in the original Canada-US Trade Agreement. It didn't get in the final draft, in large part because they were happy with other things, but they were one of the main motivations for the Americans in wanting to negotiate a free trade agreement was what we had done in investment and in energy in the 70s and 80s. In other words, the concern was Canada, when you look back to that period, was a net capital importer. Fast forward to today, Canada is a net capital exporter. But as a net capital importer, we had put in place all of these restrictions on foreign investment and had acted in a way that our major trading partner regarded as very arbitrary. And the way we disciplined that were all these provisions in the investment chapter of the Canada-US Free Trade Agreement that later get repeated in the NAFTA, what became the NAFTA, minus this investor-state dispute settlement mechanism. When it came time to negotiate the NAFTA agreement, it was very clear that the Americans wanted that agreement with Mexico, and one of their chief objectives, again, was energy. And at that point, I was a practicing lawyer in Washington for a law firm that represented Pemex, the Mexican version of what I'll call Petro-Canada. And in a sense, that was the prime objective. So since the Americans were going to go forward with that, and they weren't going to go forward with the agreement with NAFTA without having investor-state dispute settlement, they were able to get through the back door in NAFTA something that they didn't achieve but wanted in the Canada-US Free Trade Agreement. And that's to say investor-state dispute settlement. So I think that, and I think it's important to note that because in part, as we see the world that Professor Van Harten talked about, sort of seeming to recede from globalization and people going back to those 1970s policies of nationalism that we ran away from in the 80s because we realized they were hurting our economy, and that we stepped back from that. And we learned a lesson from that experience. And I don't think should go back to it. We should continue to learn the lesson. But if we didn't, apart from that, we're now a capital exporter, as we see, as Mr. Herman said. We see our mining companies or companies operating in the extractive sector, who now we are in the position that the Americans were in vis-a-vis Canada in the 1970s and 80s. That's to say, we are in a position of having to protect our outward investment. Well, how do you do that? Investor-state dispute settlement, the origins of it, if you go right back to the beginning of the time in the 1800s, if you like, was before that, the Americans would go into various Latin American countries with what they called gunboat diplomacy. And the idea was, how can we tone these disputes down? How can we avoid having to send in the Marines to Venezuela, to the Dominican Republic? Well, we can have arbitrations over disputed investments. That's kind of part of the long history of this. And so when people talk about getting rid of this investor-state dispute settlement channel, you really are talking about ramping up disputes between countries, bringing them back up to the national level. So in other words, if Canada has a dispute over a mining company has a dispute in an African country, rather than having that dispute be take place between the company and the country in a nice setting in Paris, it then becomes people lobbying you, knocking on your doors as parliamentarians and as a government, asking you to put pressure on that government. So it basically brings back up to the national level disputes that we brought down to the private level precisely to depoliticize them. And I think that's a lot of what's lost in the current discussion of investor state. The last point I'd make is perhaps just from my world tour of investor state dispute settlement, for a period of time, I was at the OECD working in the trade director when they were negotiating the multilateral agreement on investment. So I happened to be there right around the time when the ISDS provisions of NAFTA Chapter 11 began being used in a dispute involving the Ethel Corporation. So I understand why all of these sensitivities began. And I think that it's worth noting that how politically sensitive ISDS has become. And that may speak to how broad it is. It's no longer just covering the subjects of the old-fashioned expropriations. You know, Fidel Castro comes to power in Cuba and takes over the telecom company. Now we're talking about things that are tantamount to expropriation, regulatory changes. And maybe that's something that we would need to pare back. And I'm willing to have to accept that may well be a frontier that we should work on. The last part that I really wanted to come back to is my experience working in the Ontario government as the legal director of the Ministry of Economic Development and Trade. And there, I had the opportunity to advise governments a lot on these NAFTA Chapter 11 disputes. My observation is, when you listen to critics of investor-state dispute settlement in Canada talk about it, they tend to exaggerate the extent to which the Canadian government has lost. The truth is, Canada has a winning record. Most of these cases get dismissed by a margin of about 3-1, and we don't even lose. The sexy part of this discussion is always expropriation, but most of the cases really turn on something to do with fair and equitable treatment. They talk about minimum standard of treatment. And then I think the question that I think is interesting for us as Canadians to think about, and based on my observations, is that oftentimes, although the critics of ISDS like to focus on the subject matter of the arbitration, a lot of where we lose, when we lose because of the process. So we lose because municipal governments or provincial governments acted arbitrarily. And in reality, because we don't have a right to property essentially in our constitution, a lot of people don't have a remedy for those kind of arbitrary actions under Canadian law. And that's why companies go and seek recourse to ISDS. And just as support for that, I'll say that as a blanket statement, but I'll invite you to look at some of the writings of Professor Armand Demetral at McGill for the CG Center, where he actually looked at all the cases and looked at which ones might be a remedy in Canadian law, and concluded that there really wouldn't be in most cases. And for me, that's why it's there. For those of us who believed it and hoped for it, it was because we kind of would like to see a situation where our governments don't act arbitrarily. If a government has a concern for the environment, great, legislate it, but don't legislate it in the dark of night with nobody looking. If you have a concern with environmental causes, don't apply it only to one company, to a foreign company. Apply it equally. So those are my thoughts about investors. I'd be happy to answer your questions.
Thank you very much, Mr. Warner. Ms. McEwen.
Hello? How's that? Okay. Thank you for inviting me to appear on behalf of the Trade Justice Network. We're a coalition of environmental, civil society, student, Indigenous, cultural, farming, labor, and social justice organizations that came together in 2010 to call for a new global trade regime founded on social justice, human rights, and environmental sustainability. Our members include the Canadian Labour Congress, Unifor, CUPE, the United Steelworkers, the Climate Action Network, the Council of Canadians, Communication Workers of America, the National Farmers Union, and many other groups who represent people in Canada from all walks of life. So the new standard that has been set in the Canada-US Mexico trade agreement is that ISDS or other investor state dispute settlement courts are unnecessary and in fact harmful. Outside of this deal, as you've heard from the other panelists though, Canada is still part of dozens of agreements that include an ISDS mechanism. And we want to reiterate the reasons why we think that Canada should permanently shift from including these mechanisms in our trade and investment deals. So an ISDS mechanism is the clearest embodiment of the ways in which trade deals prioritize corporate rights, and not just corporate rights, it's foreign corporate rights, because if we legislate something, it only applies, an ISDS claim would only apply to foreign corporations, not Canadian ones. And so if there is no remedy in Canadian law, that's because Canadian legislators have determined that it would be inappropriate to have a remedy, that it's okay. And so why would we put a remedy in an international trade agreement that is not available under Canadian law? Why would we allow foreign corporations to have different rights than domestic corporations? And so I think that is the crux of where we disagree with ISDS mechanisms. And it actually constrains both citizens and governments in their ability to voice and protect the public interest. So as you've heard, ISDS reinforces and protects corporate rights by allowing foreign corporations to sue governments for alleged expropriation, discriminatory treatment, or loss of potential profits. And it goes beyond often protecting investors. So the obligation to compensate investors for their losses of expected profits has been applied even where the rules are non-discriminatory and where the company's profits are made from causing public harm. In a 2016 report from Gus Van Harten, he says, called Foreign Investor Protections in the Trans-Pacific Partnership, he outlines how these types of protections have really historically only benefited very large companies and very wealthy individuals. And the suits often target and suppress government action towards the public good, both in Canada and internationally. So under NAFTA Chapter 11, Canada has been brought to investor state arbitration under NAFTA more times than the United States or Mexico. And I would say this is a problem whether we win or lose the suit, because it takes up significant energy on behalf of provincial governments, municipal governments, to determine whether or not they will be in violation of an ISDS suit. And they don't have the expertise that the New York lawyers who often deal with these suits have. And so it can be very difficult for local legislators to determine if their action will be acceptable. And often what they do is they just determine that it's too risky to even try. So that problem of chill is a problem. The problem of having to deal with the suit once it's come up is a problem, and then losing is the third problem, obviously. Some of the laws or regulations that have been challenged in Canada include a proposed ban of fracking, domestic court decisions around drug patents, a ban on the gasoline additive MMT, and provincial water and timber protection policies. And so I would argue that where the problem is that it is the letter of the law that matters in an ISDS case. As Gus Van Harten said, it's fairly arbitrary who makes decisions. They don't generally have precedent, so you can't go in predict what the outcome of a decision will be. So they themselves don't have a clear process that's easy for people to tell. So there is a great deal of difficulty on the government side to establish a process that will protect them from an ISDS claim. And again, they don't have the capacity. So as we've said, Canada is now the most sued developed country under ISDS. And these cases clearly illustrate the danger of this mechanism in preventing the Canadian government from implementing policy, law, and regulations in the public interest. But as two of the panelists have also mentioned, Canadian investors are bad actors on the international stage on this front. They have used ISDS to disproportionately target environmental policy in developing nations when they file investor state lawsuits outside of North America. There was a 2019 report by Hadrian Mertens Kirkwood and Ben Smith called Digging for Dividends. And it finds that since 1999, Canadian investors have initiated 43 ISDS claims against countries outside of North America. And that these are often mining companies, and they are against environmental protections in these countries. In the report, Mertens Kirkwood also raises concerns about third-party profiteering from the ISDS system, where financial speculators engage in for-profit financing of cases. And so this speculative funding is used to encourage and sustain ISDS cases that would not otherwise be able to go forward. And so this acts as a huge barrier for climate action for developing nations who are most affected by the severe impacts of global warming and climate change. As Gus Van Harten mentioned in his opening statement, ISDS threats have also hindered effective public action during the pandemic, and there could possibly cost nations millions of dollars in ISDS claims in the years to come and prevent governments from taking action that would protect the public health of their people. So several of the actions that governments have taken in the past year that could make them a target for ISDS include restricting and closing business activities, securing resources for their health system, preventing foreign takeovers of strategic businesses that have been affected by the crisis, ensuring access to clean water for hand washing and sanitation, where they freeze utility bills and suspend disconnections, or ensuring that medicines, tests, and vaccines are affordable. For example, in Italy, after a private manufacturer failed to deliver critical parts for ventilators and refused to share the design specifications, government researchers reverse engineered the part and 3D printed them for a fraction of the cost that the private supplier had been charging. And the manufacturer threatened to sue, and the government had to back down from producing this life-saving piece. The Columbia Center for Sustainable Investment has made a call for a complete moratorium on ISDS cases during the pandemic. In June, the National Union of Public and General Employees, a member of the Trade Justice Network, wrote an open letter to Prime Minister Trudeau criticizing the threat of ISDS cases and highlighting 6 calls to action, including restricting ISDS cases and prohibiting ISDS in any future agreements. These calls are very important, as is the need to continue to educate the public and politicians about the risk of ISDS. Finally, as the committee knows, Canada failed to support a motion at the World Trade Organization that would waive restrictions on making sure that vaccines and other medical supplies for the pandemic would be affordable for developing nations. Should these nations go ahead with generic vaccine production anyway, in order to protect their people from COVID-19, they would be subject to expensive ISDS lawsuits from pharmaceutical manufacturers, who in this case, their vaccine development and trials were largely funded by the public sector in the first place. So we argue that since trade and investment should be viewed as a means to enhance material and social well-being, not as an end in its own right, that investors, even if they're Canadian investors investing abroad, if they are violating our environmental or human rights codes, we should not be allowing them to be protected by ISDS suits. Any protection of investor rights, whether within Canada or globally, should be accompanied by an enforcement of their responsibilities to the public good. Thank you very much.
Thank you very much, Ms. McEwen. On to Ms. Gray for 6 minutes, please.
Thank you, Madam Chair, and thank you to all the witnesses for being here today. Mr. Warner, I'm wondering, would you say that Canadian businesses would be less inclined to invest in countries if ISDS measures were removed or did not exist?
Complicated subject, and the economic evidence, the statistical evidence is not conclusive one way or the other. going back to my origins, as I told you, working for Alan Rugman, who was one of the guys who really worked along on this origins of foreign direct investment, I can tell you that when economists look at it, they say the greatest determinant of foreign direct investment is the size and growth of markets. And that pretty much swamps any other effect that you try to look at, whether it's taxation or anything else. But at the margins, I do think that it would hurt Canadian investments in other countries. It depends on their stage of development. More emerging markets, it tends to be something that companies need. And a practical matter, what it means is this: companies, if they want to invest in a country, if they can't get a remedy through something like ISDS, they're going to look for some kind of insurance. And where are they going to look for that insurance? You can say, well, let them pay for it. Well, we live in Canada. Let's be frank about it. They're coming to you or some bank you will set up. And they're going to ask that bank that you set up, and we fund as Canadian taxpayers to pay for it. It's not some great independent insurance market where they're going to get it. So what ISDS does, again, is it allows you not to have to fund it through a really highly subsidized insurance scheme. And without the insurance and without ISDS, they won't invest, it seems to me. So you can have it either on the front side or the back side, but one way or another, if we want our Canadian companies to go into those jurisdictions, we're going to end up having to have something like that to deal with it.
Great, thank you, Mr. Warner. And also to you as well, some worry that ISDS provisions would prevent Canada from enacting legislation such as on the environment or maybe other factors without facing challenges from corporations. Would you say that this concern is valid?
I mean, I think that what is fair to say is that, where we have tended to lose cases or where we see cases really brought, it's under this idea of the fair and equitable treatment of the investor. It's not really under the expropriation sort of heading. And so it's not that we're losing because panels have come in and said, oh, Canada, what you did is really bad by implementing this new substantive legal obligation. Where Canada loses is when people say, wait a sec, you mean you told the investor one thing one day and on the next day somebody else gave you some more money and you changed your mind? Where they say, wait, we had a deal with you, we gave you some money, you told us there were these regulations, we incurred cost, and then you just changed your mind because some municipal government said, oh, I don't have to pay because the federal government's going to pay for it in effect. So those are the cases we actually lose. So I don't think it changes our ability to enact environmental law or pharmaceutical policy that we choose. What it says is that we have to be more careful when we legislate so that we don't discriminate against particular investors when we do it, and that we do it in a way that conforms to some sort of notion of due process, for lack of a better word. So I don't think it really does hurt our ability to substantially legislate in those fields.
Great, thank you, Mr. Warner. It sounds like you're saying a lot of it has to do with certainty, if someone's going to be investing. What risk do you foresee for Canadian businesses abroad if Canada were to remove foreign investment protection agreements it has signed with countries across the world?
Is that for me? Okay. Well, look, I think that if we didn't have investor-state dispute settlement, then Canadian companies are going to have to figure out where they go to get a remedy. And as I said before, they're going to either not invest, so we'll lose out on that on the returns that come to us through taxation, or two, we'll pay for it in the form of insurance, or thirdly, they're going to ask you as a government to make the decision for them, and every time you sit down with representatives of their government. And there may be cases, particularly in Africa, where our foreign policy demands that we have a good relationship with a country that has a huge mining industry. But if every time we sit down with that country, the top of the agenda is that investment dispute, we won't be able to pursue some of the foreign policy objectives we have on a bilateral basis with that country, but let's be frank, on a multilateral basis in larger international institutions. So I think it hurts us.
Thank you, Mr. Warner. I've got less than a minute here, so I just did want to squeeze in. We've heard that the government is in consultations for a trade agreement with Indonesia, and according to the World Justice Project, has a rule of law index score of 0.58 compared to Canada, which is 0.75. So would you recommend that Canada seek to negotiate some form of ISDS provisions in a potential Canada-Indonesia free trade agreement?
I mean, the short answer is yes, I would. I think there's no reason to depart from what our practice so far. We are a capital exporter, and I think the norm so far is to have ISDS in those provisions, even regionally, because it is, of course, in our existing CPTPP agreement regionally. So I would see no reason to depart from that.
Okay, thank you very much, Ms. Gray. On to Mr. Dhaliwal for 6 minutes.
Thank you, Madam Chair, and thank you to all the presenters. Excellent information. Madam Chair, most of the questions that I had were touched up by Ms. McCune, that was on pandemic, environment, and social justice. I'm going to start with pandemic. To what extent could pandemic-related measures implemented by our government expose it to legal repercussions under ISDS provisions in international trade agreements, as we have many trade agreements that has this provision? If can speak, please.
Yeah, thank you for the question. There are the Columbia Institute that I mentioned and other legal organizations in Europe have definitely made lists, and I can share that with the committee of potential cases. There was a lot of concern at the beginning of the pandemic that these would be coming. And I think what we saw was letters of threat from some, and then backtracking from governments. So unfortunately, we don't know that because often those communications are in private. But I can send you the list of the extent. I think it's significant.
Okay. And any of the other witnesses want to chip in? No? Okay, my next question then goes to, because our government is big on environment and social justice policies when we are signing up those agreements, and some has expressed concern, and you have expressed concerns as well, that ISDS provisions hamper environment and social justice policy by imposing some penalties on any country that attempts to regulate in public interest. Could you please give your thoughts on, whether this may be the case when it comes to, these issues, and how we can improve on it as a government if we sign further agreements and we have a chapter on environment and social justice policy?
Exactly. So these trade agreements that we've signed, for example, the one with Europe, where we have an investor court system in place, the investor protections are guaranteed at this tribunal or at this court, but the environmental protections don't have the same weight. And so we mention environmental protections, we mention labor protections, we have wonderful language, but there's no enforcement of them. And there's no relationship between the investor protections and the commitments that we have referenced in the environmental or social justice chapters, or the other treaties that we've signed on to, for example, at the International Labor Organization on Labor Rights or the Paris Agreement. And so if you take action as a government actually to meet your climate targets under the Paris Agreement, that does not protect you from an investor dispute if you are appropriating rights. So there is no you can't use that to justify action that you've taken. And what we would call for is that there are actually binding restrictions in the agreement, binding references to other international treaties that we've negotiated, either for climate or for labor.
But when I look from the other angle, the ISDS provisions are implemented in many of the trade agreements, as mentioned by Mr. Harman. But I look at the other way. If we did not have these ISDS provisions, incorporated in those agreements. No, not having that dispute settlement system, some of the trade agreements that we signed, the companies, particularly the Canadian companies, would face challenges if we did not have those provisions.
Absolutely, but I question why we would want to actually insure Canadian companies that are behaving contrary to our international obligations under labor rights or environmental rights. I don't think we have the responsibility as a government or as the people of Canada to either insure them through this costless, supposedly costless to us, investor state dispute settlement mechanism. We should make them buy insurance if they want to invest, because if they want to invest, it's because they expect there to be profits, right? And so it's not our responsibility to insure them against their own bad actions in generating profits. And I think that we should, I know that you hear from us politically on a regular basis about the bad behavior of these corporations in the global south anyway. So having ISDS does not diminish the political pressure that we're applying to you about the bad behavior of some of these Canadian. It really, Canada is a flag of convenience for mining companies. It's awful and it's horrible. And I don't think that most Canadian citizens would support our public dollars or our foreign policy backing these organizations.
Thank you very much, Mr.
Thank you.
Ewan. On to Monsieur Savard-Tremblay for 6 minutes.
Merci. Bonjour, merci Madame la Présidente, salutations à mes collègues, merci à l'ensemble des...
Thank you to the chair and all the witnesses. Mr. Van Harten, you explained why, in your mind, this mechanism was harmful politically. I agree completely. There was a report made, I think the data is not up to date, from the United Nations saying that 60% of cases in the world, not only in Canada, were defeated or were agreed to. The European Union also did a report on the impact of these clauses on states. They create a climate of censorship where governments will refrain from adopting certain policies because they don't want to be sued. Do you have examples of those?
For the question, I entirely agree. A report that counts the number of wins and losses isn't telling us that much about the impact of ISDS, because the real impact is behind the scenes. To get at that impact is very difficult for an outsider. I've tried by interviewing officials. And I think there are many examples of governments changing their decisions as a result of ISDS risk. Now, whether or not the change was good or bad could be argued. But I can tell you there are many, many examples in many countries where behind the scenes decisions have been changed, and sometimes in ways that are pretty alarming. The Ethel case is one of the most famous settlements in the history of NAFTA, one of the early cases where Canada had a very concessionary settlement, including the withdrawal of proposed legislation. It's a long story. I don't want to draw us into that rabbit hole. But I would say what happens with ISDS is the question of the merits of a decision is no longer left to the institutions of the country, ultimately, to the government, to the legislature, to the Supreme Court, the ultimate decision maker becomes a panel of arbitrators whose role is triggered by a multinational. And that extraordinary change in the decision-making infrastructure of your sovereign country leads to all kinds of pressure behind the scenes. And I would say above all in a crisis. Any kind of crisis, this behind the scenes pressure is going to be bad for any Canadian perspective that differs from that of someone who can claim to be a foreign investor and has enough money to bring a credible threat of a claim. And that means it could be an economic crisis, it could be a financial crisis, it could be an environmental crisis, or it could be a public health crisis. It's not good. And I fear we're going to face more of those crises in the future. So there are plenty of examples of this. Quickly, just to highlight, many trade agreements do not allow for ISDS. The new NAFTA has removed ISDS between Canada and the United States. That's one of the most positive things I encountered in my couple of decades following ISDS, and it came from the Americans. The Americans decided ISDS was too much of a constraint on their own sovereignty, and among other things, it created incentives for American companies to move manufacturing abroad, was a concern. So I'm saying US-Canada relations will always be fundamental for us. I, by the way, completely respect and defer to the wisdom and expertise and experience of others on the panel. I'm just saying it's case by case, treaty by treaty specific, how you withdraw in a non-provocative manner that doesn't offend relations with the United States, doesn't offend multinationals, doesn't say Canada's going back to the bad old days of the 1970s where, you know, Pierre Trudeau was friends with Fidel Castro, I don't know what. Okay, so it's looking forward. We need to free ourselves from ISDS because of the crises that are coming in the future. And just because of this point, we cannot have our governments being deterred behind the scenes from essential steps they need to take to protect Canadians.
Thank you very much. On to Mr. Johns for 6 minutes, please.
Well, thank you. Thank you to all the witnesses for your testimony. Ms. McEwen, in your opening statements, you mentioned that the investor state dispute settlement provisions in relation to vaccine production. Can you explain to the committee more fully what the TRIPS waiver is and how it demonstrates exactly how dangerous the ISDS provisions are?
Yes, thank you for the question. So TRIPS is a treaty on intellectual property rights at the World Trade Organization. And there's a TRIPS council that meets regularly. And they have in the past actually allowed waivers of intellectual property in certain circumstances. And so in the middle of the pandemic, India and South Africa, who have both been badly hit by COVID-19, proposed to this committee at the World Trade Organization that they suspend the intellectual property rules to allow them to produce vaccines, generic versions of vaccines, because they have generic manufacturers there where they could do that, and that would allow their population to be vaccinated more quickly, which actually protects global health. But they also wanted to be able to manufacture parts for ventilators, PPE, and other things that might have intellectual property restrictions on them. Now, what Canada and other rich countries have said in this council is that, well, prove to us that this is delaying your response. We think that you can resolve this on a case-by-case basis. We think that these huge global profitable corporations that have never seen more money come into their bank accounts, we think that right now they're probably going to be in a good mood and they'll let you do this. We don't have to go to this extreme of lifting the whole waiver, of lifting this whole provision. And the countries came back and they said, here's an example of where we've been trying to do this and where it's been stalled and where it's taking us a really long time. And it's hurting us, where there are people dying in our country because we're not able to provide affordable the stuff that you need to do the testing. We're not able to provide these things in an affordable basis because of this intellectual property restriction that you're refusing to lift on our behalf. And so Canada has still, there was another meeting, Canada has still said, well, no, we think that you're probably fine, that we don't need to do this. And so we think that in the interest of global public health, just in the interest of human rights and basic decency, that in an emergency like this pandemic, it makes sense to lift that that intellectual property rule that says these companies get to negotiate how much they can be paid. It's a little bit like Uber drivers, right? When the surge pricing. But what's happening is in the absence of this waiver, the global north is protected. We're vaccinated, but you're going to keep seeing more variants be produced in South Africa, in India. You're going to see more people in the global south dying from COVID-19 because we did not act swiftly and allow these things to be produced in a generic way that would be affordable for these countries.
I want to drill down a little more on this. Maybe you can talk to the committee about how many countries have signed the waiver, how many groups have been pushing the Canadian government to sign onto the waiver. When is the next opportunity for the Canadian government to sign onto that waiver at the WTO? And has the Canadian government responded to any of your concerns around signing onto the waiver? Maybe you can also speak, there's a lot of public money going in right now to the crisis and how responsible this is right now.
Yes, so you raise a good point. The major vaccines were actually funded mostly through public money. The Moderna vaccine, the innovation behind the vaccine was created by scientists, publicly funded scientists in the United States, and they have the patent for it. But still, somehow, Moderna and the other companies have a right to license the end vaccine. The trials were funded by public money, and Moderna, which is completely publicly funded, like everything about Moderna's vaccine actually was funded by public dollars. They had the highest price for their vaccine, which is completely unacceptable, and they're looking at making a huge profit from this vaccine. But yes, the majority of countries have signed on to the waiver. Canada, the US, the UK, we're dragging our feet. We haven't said no, but we've said, look, we need more evidence that this is causing a problem. We've written letters. So CUPE has written letters, the Canadian Union of Public Employees, the Canadian Labour Caucus, many of our members have written letters. The Doctors Without Borders, Amnesty International, there are Public Services International, there are global campaigns pushing governments to make this decision that would save lives. And we've heard no response. So what the Trade Justice Network did, what I did, was I started a petition with the House of Commons. There's an official e-petition. And then because we have over 500 signatures already, the petition will close at the end of March, and the government will have to respond to our petition. So we are expecting that we will get a response from the Government of Canada at that time, but we've had no response to date from them.
Thank you very much, Mr. Johns. On to Mr. Lobb for 5 minutes, please.
Thank you, Madam Chair. Can you hear me okay? It's been a great conversation so far this morning. I just wanted to really ask Mr. Warner a question, and it's in regards to WTO dispute mechanism and the ISDS mechanism, and really, when is it in the country's best interest to go forward through WTO, or when would a company decide it's their best interest to go through ISDS, or is it a concerted effort to go, a dual approach? Just wanted some thoughts on that.
So they are, they are two obviously very different processes.
Yep.
I think from a point of view of a company, the decision to go to the ISDS puts more, gives it more direct say, because of course the WTO proceedings are state-to-state proceedings, and so the best the company can do is go to you, government in Canada, and say, will you take our case and will you argue it in the Geneva proceedings and go through the consultations with the governments, etc. So governments defend in ISDS cases, but they aren't the lead. They aren't the proponents, and so the investor, I guess, has more sovereignty to make up the arguments it wants to make. And so, if you're well funded and you can afford to do that, it might give you a better resolution than trying to rely on the state-to-state dispute settlement process. So I think it's really the kind of calculus that a company goes into in deciding whether to ask its government to pursue the matter through any number of trade agreements, including the WTO, or to take matters into its own hands.
Maybe you don't want to comment on a particular case or a potential case, but do you believe that Huawei will have a great case if Canada makes a decision one way or the other?
Well, I think I should say I sort of send this over to, if I don't mind, refer your question to Mr. Herman, because he's written, I think, a very good article on this subject and what to put him on the hot spot.
Mr. Herman?
Well, as I indicated, we have an investment treaty with China. Most people don't think about it or talk about it, but it gives Chinese investors rights to bring binding arbitration against the Canadian government for breaches of the treaty. And that means breaches of the obligation to provide fair and equitable treatment to investors. But that treaty, the Canada-China Investment Treaty, has an exception for national security interests. And my sense is that exception would cover Canada in the event that Huawei were to bring arbitration proceedings against Canada.
Okay, that's good. Ms. McEwen, I guess the one I was interested in is on Keystone XL. And maybe you don't want to comment, maybe you do, but because it is an old file that predates USMCA, do you think that a company like TC Energy, TransCanada Pipeline, should be able to sue the US government or state government because of the canceling of Keystone XL? Any thoughts on that one?
Well, sure. I can just tell you factually that because it is an old case, like ISDS is not completely out of CUSMA. It's being slowly weaned out. So investments like that one would still be covered by ISDS. Whether I think that's a good idea or not is a different matter.
But in that one, and I'm not trying to make you say one way or the other, you're free to answer any way you like, but can you not see from I look at from this perspective, it would seem to me that is a good provision to have to protect TransCanada Pipeline from a decision that's covered 3 presidents and billions of dollars of investment.
Absolutely. My argument there would not be with the specific investors. It would be with the government for not providing clear direction and guidance ahead of time when it was clear that investment would likely not go forward. To be fair to the government, they were trying to follow a process, as Mr. Warner states, that would allow them to say no. So whether they intended to say no from the beginning or not, they had to go through the environmental protection process to allow them to deny that investment. And in doing so, they actually, dragged the investors along potentially longer than they should have.
Thank you, Ms. McEwen.
Yeah.
On to Mr. Raya for 5 minutes.
Thank you, Madam Chair. Mr. Mark Warner, thanks a lot for bringing out the history of these mechanisms and emphasizing the importance of this mechanism in depoliticization. That's a very excellent point many of us forget. And also twice, you mentioned we are becoming a capital exporter. The capital export is still growing. And Mr. Lawrence Harman, I did read the note that you circulated, and I have to state, let me just quote the last para of your note. You mentioned the need for modernization to make the ad hoc arbitration process more efficient and effective and consistent. That is very, very important. You also touched on state-to-state obligations. Once again, many of us forget of that. The foreign investment from protection and promotion agreements are a fact of life today. We are, the Canadian companies earlier in the previous generation, I can say it was few mining companies that were investing abroad. But these days, lot of Canadian investment is going from the Canada Pension Plan or the OMERS or the TTS pension, and we have been investing elsewhere. To take a specific example, Canadian investments in India is about $52 billion. And we don't have a FIPA yet. We don't have any foreign investment protection agreement with India. So what is the mechanism available for Canadian capital exporters to protect our investments? Many times just because few Canadian mining companies acted in a wrong way to brush everybody with the Canadian companies are bad actors is something I don't agree with. I think we need to have a mechanism where the funds of an average Canadian that is invested through our pension plans, whether the CPP or OMERS or teachers, what is the mechanism available when they invest in Asia and South America, for example, in India, where we don't have any production agreement?
Are you asking me,
yes,
Mr. Are you? Well, when it comes to India, we don't have a FIPA, and so there aren't any state-to-state obligations that Canada could rely on. It would be up to in that case, the investors to assess their risks and to make decisions accordingly. That's just the way the market works. Some people say that investment protection agreements unfairly, I guess, one way of expressing it, unfairly underwrite investor risks, and that it's up to the investors to make the decisions of whether they want to invest in a particular jurisdiction. But to answer your question, there would be no way in which an investor in, let's say, India could be protected other than recourse to Indian law in the event of some behavior that was illegal or improper. So that's the short answer to your question regarding India in particular.
So we have a practical case here. When Canadian investment, when I say Canadian investment, I'm talking about some mining company investment. When an average Canadian investment, average Canadian like you and me, our investments through our pension plans get invested in various countries because we need to invest in other countries to generate returns for our pensions. So when we make investments in countries in South America or Asia, doesn't that emphasize the need for having this investment protection agreements?
Well, in my view,
short answer, Mr. Herman.
In my view, yes, it does. But those agreements can be drafted accordingly, provide the necessary guarantees and protections for the host country vis-a-vis the investor that we talked about, but would also give the investor a framework for bringing action if that investment was unfairly treated.
Thank you, Mr. Herman. On for 2.5 minutes to Mr. Savard Tremblay.
Thank you. I will ask a question of Mrs. McEwen on the following. As we know, there is this protection for foreign investment. If we read the content of these agreements, there's a very financial definition. So we're not talking about creating job or creating wealth. It's a transaction through a company. Okay, so that's an aside. But this protection of multinationals in order to allow them to begin an action against the state, but there's nothing that protects citizens against abuse, citizens that might be victims because of the behaviors of these same foreign investors. Do you think that there's a flagrant unbalance in these agreements?
Absolutely. That is the central problem with investor-state dispute mechanisms, is the imbalance that it gives large investors, large foreign investors, against states. And so the only reason you would need an investor-state dispute settlement mechanism for investment in India is you didn't trust the government of India to behave consistently, if you didn't trust their court system to treat foreign investors equivalently to domestic investors. And so if we're afraid that our investments will be counter to what the government of India wants for its people, I think that the government of India has the right to say what it wants for its people. You know what I mean? That's democracy. And so the fundamental thing about investor-state dispute settlement mechanism is that, and what advocates say about it, is that it ties the hands of democratic governments to privilege the rights of investors over the public good. And so it doesn't always work out that way, but that is its entire purpose and goal. And so I would argue that if we want democracy globally, we have to trust democracy globally, and we do not need to handcuff other governments and prevent them from acting in the best interest of their citizens.
Thank you. Madam Chair, how much time do I have left? Well, in that case, I would like to thank Mrs. McEwen for an answer.
On to Mr. Johns for 2.5 minutes, please.
Thank you. Ms. McEwen, Brenda Sayers from the Hoot-Petchesis First Nation in my riding went to court regarding the Canada-China FIPA agreement, concerned about Indigenous rights and the sovereignty of the people there. She's concerned that foreign companies could come in and buy part of the watershed through a tree farm license and impact wild salmon and obviously clean drinking water. We've heard many times that the Canadian government is committed to reconciliation, to the United Nations Declaration on the Rights of Indigenous People. In fact, we have legislation before the House right now. My NDP colleague tried to include a non-derogation clause in the ratifying legislation of the Canada-UK Trade Continuity Agreement to ensure that Canada's trading partners are fully aware of Canada's obligations to First Nations and Indigenous peoples. It's disappointing that the amendment was voted down, given that the Trade Continuity Agreement does include ISDS provisions as well as with CITA. I'm wondering if you can clarify how the ISDS could impact the government's abilities to fulfill its obligations to Canada's Indigenous peoples.
Thank you. That actually highlights a gap in my presentation, where I spoke about our international obligations through the Climate Accord or through the ILO. But the United Nations Declaration on the Rights of Indigenous Peoples is actually something that we have signed on to internationally. We have committed to, at least rhetorically, at the federal level, but we have signed treaties that will not allow us to fully enact that rhetorical responsibility that we have agreed to. And so I have worked with Pam Palmer on trade agreements, and what she says is that actually we need to have Indigenous representation at the bargaining table to fully realize UNDRIP and trading rights. And so we are so far from that in trade deals that what we have right now absolutely contravenes UNDRIP. Thank you.
We hear at this
28
committee.
seconds, Mr. Johns.
Thank you. Regularly that the climate crisis is one of the defining things about our generation. And I'm wondering if you could explain how ISDS has negatively impacted or cost Canadian taxpayers money when making changes to our regulatory framework, and maybe if you have a couple of quick examples.
Very briefly, please.
Sure. So, I mean, I think the first example that everybody knows about is Ontario tried to do a climate response where they bought locally, and that was struck down internationally. They didn't do it the right way. I maintain that they could have done it in a way that would have been consistent, but they were unwilling to actually make the effort to kind of break through and do it in a way that would have been consistent with international law. They tried it one way, it didn't work, and they gave up. When I worked for the Department of Agriculture in Nova Scotia, I proposed a whole bunch of ways that we could compensate farmers for actions that they'd taken to be sustainable. And it was killed actually probably at the deputy minister level because he's like, well, I think we would get sued under ISDS for this. And I'd given examples of European countries that had similar policies in place, but it was, and so I think those are the examples of where silencing really matters and you never hear about it.
Thank you. Mr. Abutai.
Thank you, Chair. Thanks to your our witnesses this morning. Question to Mr. Van Harten. He's been called for canceling or withdrawing from the ISDSs. Two questions in one at one time. The first question is, does that hurt or can that hurt our investment trade balances, especially with the major agreements that we have in place? The second question is, how does the industry react or can the industry react to such thing? Thank you.
Thank you very much for those questions. And just as a prelude, let me say, withdrawal is not going to happen quickly. Withdrawal will take a generation to withdraw fully from the obligations we've assumed under existing treaties. My view is our general stance should be to prioritize withdrawal where possible, depending on the treaty, depending on the context, and certainly not to agree to ISDS anymore. Now, how will this affect our investment relations, and how will it affect Canadian investors abroad? I think it's so hard to predict how investment relations and the economic benefits of investment, which are clearly tremendous, how those are affected by current ISDS treaties, let alone future ISDS treaties and the prospect of withdrawal. I would say the risk of negative impacts simply from withdrawing from ISDS treaties would be low, and we can keep it even lower if we do it in a quiet, non-provocative way, which was essentially South Africa's approach when it withdrew from its ISDS, bilateral investment treaties that allowed for ISDS in the last 10 years or so. They did it in a way that reassured foreign investors there were other protections available. New legislation was passed to make those protections more robust in South Africa. And for Canadian investors abroad, yes, you're not going to have access to the treaty ISDS anymore. But for many investors, the most important Canadian investors' assets we're concerned about are the really big ones, the multi-billion-dollar assets that we do not want to leave completely open to abuse by some government abroad. And here there's always a very complex set of contracts between the foreign investor and state entities in the host countries. And a large multinational is sophisticated in its ability to negotiate contracts that protects its interests, including by providing for ISDS. You can have ISDS under a contract that leads to essentially the same process. I think that is preferable for a host country because you can be more selective. And when you're making these extraordinary concessions of your sovereignty and your regulatory flexibility. So that's got to be one component of a gradual plan to withdraw, is to make sure the contract-based ISDS is well known to major Canadian investors abroad, that they have capacity to pursue that means of protection. And secondly, political risk insurance is available. Mr. Warner has referred to it. It could be state-backed. It could be in the marketplace. It's far from perfect. I would stress that the insurers are much smarter than the drafters of the treaties because they limited the obligations. You don't get an obligation to insure for breach of fair and equitable treatment in a political risk insurance contract. You get safeguards against the more obvious and more controllable risks like nationalization and expropriation, which we absolutely should be protecting investors against. And so I think Canadian investors will have some setback. They will not be as well off, but if you look at it in terms of the benefit to Canada overall, what we pay monetarily, what we pay in our loss of capacity to respond in a future crisis. I'm telling you, when the future crisis comes, government officials will be thanking the heavens if they don't have to worry about ISDS risks in the billions of dollars. And that will be well worth it to ensure Canadians can be protected, even when one multinational, for whatever reason, fights really hard behind the scenes to stop us doing what's right for Canadians. We just need to get that obstacle out of the way. And I think a Canadian investor who sits down and looks at the quid pro quo will say, we can manage to protect ourselves with governmental support, and we're Canadian too, and we can see the value of protecting our country against these broader risks. But all that sounds a little provocative, I'm sure. I don't mean it to be provocative. I've been banging on about reform of ISDS for a long time. I just have come to the view, keep it simple, withdraw, and then reform ISDS. Don't stay stuck in it. Sorry for going over there.
Thank you. On to Ms. Badayan for 5 minutes.
Yes, thank you, Madam Chair, and thank you to all of our witnesses for this very thoughtful discussion this morning. I guess as a point of disclosure, I should mention that previous to my political career, I was a lawyer in international commercial arbitration and did represent several companies, including some that we are very proud of here in Quebec, like Bombardier, against foreign states under arbitration provisions, similar to what Mr. Hartman was just describing as ISDS provided through contracts. Of course, I also did some ISDS through our trade agreements. Nevertheless, without putting any of my personal opinions on the table, I think that it is important to discuss how Canada should move forward, particularly as we negotiate new trade agreements. But before I ask a question, just as a point of clarification or correction, Mr. Hartman did say on the record that it was the United States who asked that ISDS be removed from the new NAFTA. I don't think that any of us who were not in the room should presume how those negotiations went down or what Canada's position had been at the outset. And also with respect to just a previous conversation regarding the United Kingdom-Canada transitional agreement, to note that the ISDS provision is suspended in that agreement. It would only come into force much later if the ISDS provision in CIIT would be ratified, which, as we heard earlier today, and as we all know, is possibly not going to ever happen. To get to a substantive question, perhaps for Mr. Warner and Mr. Herman, I wonder if you could comment generally on your feeling about taking a case-by-case approach. Perhaps in some situations dealing with certain trading partners, ISDS could be used, whereas in other circumstances, for example, when dealing with partners for whom we have great confidence in their own judicial system, if it were unnecessary in those cases. Perhaps we can start with Mr. Herman.
Well, first of all, Ms. Bendayan, your reputation before you took the political turn is well known, and your involvement in these cases by those of us in the field are well appreciated. Just one comment I would make about withdrawal from current ISDS provisions. Our first investor-state treaty was with Russia. And I would ask at some point, Mr. Van Harten, to answer this question. Is it in Canadian interests to withdraw from that treaty with Russia? That's a question. But your point, Ms. Bendayan, is should we approach it on a case-by-case basis? I think that is a viable approach. Look, we are eliminating investor-state disputes with the U.S. They are eliminated for all practical purposes with the Europeans. So the question is, where are the Canadian interests affected? Where are the Canadian interests affected? If we're not going to be subject to investor-state arbitration from American investors, and the same for European investors, where are the Canadian interests that are somehow in jeopardy? My point is that withdrawal from existing treaties, foreign investment protection treaties, is fraught with difficulties. It is possible in future cases, to come to your point, to be selective and to decide where we need some ISDS provisions with the guarantees that have been built into the CITA provisions, where you have an appellate process and a standing arbitration court. That, to me, improves the system remarkably, and that could be part of a policy going forward for any new treaties that Canada is seeking to negotiate.
Thank you very much, Mr. Herman. And
Sorry, your time is up, Ms. Vidayan. You've got 18 seconds left. So
I think could Mr. Warner please comment, perhaps? With
sure. Just very briefly, I agree with much of what Mr. Herman has said on that subject. I would say that I think in reality, the way it will play out for Canada is that now that we have taken it out of our agreement with the United States, that going forward, other countries will ask for equivalent treatment. I think that's how it will play out with Canada.
thank you, Mr. Warner. On to Mr. Hoback for 5 minutes, please.
Yeah, and actually, Mr. Warner, that actually, you bring up a good point in that comment. When you go to countries where you feel you really do need appropriate ISDS protections because of their court system or because of their political system, how do you negotiate that in that scenario?
Well, it's tough. I mean, I think that if those are exactly the countries that are going to stand across from us in a negotiation and say, well, if you didn't need it with the United States, why would we put it in agreement with you? I don't know how we're going to answer that. And, it could just be that if the interest in having an agreement with us is so substantial that they will accede to it. But I think that's going to be a sort of one of those unintended consequences of the last go around with the CUSMA that is yet to play out. But it will be very tough to get this. Certainly with bigger players, I think with Indonesia, for instance, could very well look at us and say, you got to be kidding, because they're very nationalistic as well.
So one of the problems I have is that we hear from other parties saying this is a huge issue for Canada. When I go back and look at the record, we've lost 8 and won 9 cases against Canada. We've paid out $219 million in damages yet, and about $95 million in legal fees. Yet we received some $410 billion worth of foreign direct investment. So how big of an issue is it in Canada, and how restrictive is it? And are we concerned about investment in Canada, as we're seeing now with this government? They put in policies that make sure nobody wants to invest in Canada. So is it now more the concern that, okay, how do we protect Canadians who invest outside of Canada? How do we take that small company that has maybe $10 million of sale and says, you want to break into a new market, let's say Europe or the US, but I want to make sure I have protection, yet I can't buy that protection. I'm not a big multinational that's going to actually go to the courts and sue a state or the federal government in the US. So what else other than ISDS do we put in place to protect those small businesses?
Is that for me, sort of thing?
Yes.
Okay.
Sorry.
Yeah. I think that I suppose if once ISDS is out of the U.S. agreement, we're going to be asking basically to politicize every trade and investment dispute all over again. And there's no shortage of things on the list of disputes with the United States, from softwood lumber to Keystone or whatever else. So there's only so much time and attention you can have with the United States when you're Canada, and I don't know if you really want to convert all of these. So we're going to be asked to, I think, spend a lot more money in supporting individual Canadian companies in making these kind of, bringing these disputes forward in the United States in the absence of ISDS, seems to me.
And then, Mr. Warner, just talk about buying insurance. So you could buy insurance for political risk from EDC. And let's say you actually go to collect on that political risk. Who ends up paying the bill if it's EDC paying out that insurance premium or that policy? Is it actually not the Canadian taxpayer, or are they actually other companies that they're also buying risk insurance from EDC? And if we're to see a massive payout, who at the end is on the hook? Is it Canadian government, or is it the foreign government that actually went and nationalized the Canadian company or made decisions arbitrarily against the Canadian company?
Seems to me that if it's EDC paying for it, then we are the ones that ultimately will be underwriting that risk as Canadian taxpayers. And that's just part of the unintended consequences of some of these proposals.
Mr. Van Harten, I asked the question, Mr. Warner, before about these small businesses. They do $10 million worth of sales. They decided to get into the export market because we've been promoting them to be an SME that's exporter. So let's say they do invest in, let's say, a warehouse distribution or something in another country. How do we protect their investments? What do we do for them?
Mr. Holbach, totally fair question. Important question. I want to support entrepreneurial Canadians doing business abroad. I take my hat off to them. I mean, I'm an academic. In the private sector, they expect results, as they said in Ghostbusters. I mean, I have the utmost respect for them. I just want to tell you honestly, ISDS isn't going to help because they can't afford the litigation. And you're dealing with a country like, let's take Russia or China. Even if you win in ISDS, millions or tens of millions in litigation fees later, do you think the country's going to pay? The Russians, they might not pay. So then what do? Then you have to chase Russian assets in countries all over the world, waving around an arbitration award and an investment treaty. And, it's great for the lawyers. It's great for the arbitrators, but I'm just telling you straight up, unless you're talking, hundreds of millions in assets, the benefit to Canadian investors being protected abroad, you're just going to have to look elsewhere for your protection.
So in other words, then in our trade agreements for these small and medium enterprises, we actually have to look for a different mechanism to protect them. Is that fair to say?
Yeah, we need state to state. Briefly. I think will help more. State to state will help more. They got to look at their contracts, but at a certain point, it's an ugly marketplace out there, and make your decisions accordingly.
Thank you very much, Mr. Sarai, for 5 minutes.
Thank you, Madam Chair. I guess I'll give this question out to let's see, Mr. Van Harten. Similar to what others have said, I still have mixed thoughts about ISDS. We've heard Mr. Holbach has just stated as well. We've won a bit more than what we've lost. What are the potential risks of not having an ISDS? Particular for SMEs that go out and venture, and especially new technologies that may be disruptive or maybe state of the art, which other states may not like or use protective measures to shut down.
Thank you, Mr. Sarai, for the question, and I think treaty-based ISDS in most contexts is not going to do anything for companies that have assets below hundreds of millions of dollars at stake abroad in the country. There should be a sequenced approach to managing the Canadian interest in withdrawal and the Canadian investor interest in still having sufficient protections that are tailored to that investor's needs. So, for example, the highest priority was always NAFTA, and we're out of ISDS under NAFTA. Box ticked, great. Thank you very much, Minister Freeland. I emailed her at the time to thank her for basically asking for Canada what the Americans were demanding for themselves. The Americans wanted to keep ISDS for Canada and Mexico, but not have the obligations themselves. Well, that was a non-starter for our government, and I want to say thank you for that. So beyond that, I say keep CITA provisionally applied and keep ISDS out and do it quietly, but make sure ISDS is not coming in, and don't leave it just to European member states to not ratify. Make that clear that that ISDS is never going to be applied under CITA. I will be so happy for Canada on that day. Next, the CPTPP. Oh dear, that was a turn in the wrong direction. At the time, we were changing ISDS and the CITA and actually getting ready to get out of it in the NAFTA. But look at the example of New Zealand and Australia. They have side deals under the CPTPP that removes ISDS as between them. I don't see how we can't conclude similar side deals with those same countries in the TPP. And as for the bilateral investment treaties, a bit of a different story. But if you want to protect Canadian SMEs, there are far more important measures that can be pursued at a lower level than the grand claims of treaty-based ISDS. Thank you so much.
I'm going to pose the same question to Mr. Herman. How do you think we can modify maybe ISDS for future provisions or in current or with side agreements, as Mr. Van Harten has said, to still protect our interests where they're unfairly hindered by different states, at the same time also allowing us to protect our sovereignty and our own environmental and labor laws?
Well, look, as I said, we don't have ISDS with the Americans anymore, so that removes a huge swath of risk. I don't think we need to get overly exercised about ISDS going forward with the Europeans. It's probably not going to happen. Where are Canadian interests? Where do they lie? I don't quite understand the notion that we should abrogate existing treaties, get out of existing foreign investment protection agreements. I don't understand how Canadian interests are advanced by doing that. I may be missing something. It may be desirable from an academic perspective, but why would we withdraw from those treaties where there is benefit, arguably, and no disadvantage to Canadians in terms of Canadian interests? We could negotiate under the CPTPP bilaterals to eliminate ISDS. I don't think there's a huge risk of foreign investors from the Asia Pacific region attacking Canada. It may happen, but I think that there's a lot of atmospherics about ISDS. Frankly, I think we have to sit back. I think you have to sit back and determine where Canadian interests lie. I'm not talking about broad academic interests. I'm talking about hard Canadian interests.
Thank you, Mr.
Thank you very much, Mr. Herman. On to Mr. Savard Tremblay for 2.5 minutes.
Oui, merci.
Thank you. Well, I was listening to what you said about keeping the mechanism. Some said we need absolutely to keep it, and that most of agreement reproduce them. But the CUSMA doesn't use this mechanism. Perhaps Mr. Warner can answer my question, who said he's for this mechanism. But since the CUSMA entered in force, sorry.
We have not really exited the NAFTA yet from the point of view of investor-state dispute settlement. That will happen next year because now there's this transitional period. So we haven't really seen that effect. I think what's interesting to see, I think someone mentioned Keystone so far. What's interesting so far is that when the NAFTA was in effect, the TransCanada, as it was then, did sort of launch an investor-state dispute settlement case that they withdrew when Donald Trump passed an executive order to let the project go through. What's interesting, in this transitional period, TC Energy has not reinitiated a similar measure, which they are entirely entitled to do. And I don't have a complete answer to that. And I keep asking.
Anyway, thank you very much. But if we look at this, United States and Canada are countries that have developed justice systems. They have laws. They can, they can take care of their own disputes by themselves. Why do they need something else?
It's involving Lowe in a funeral home, which is one of the golden oldies you can read about in any of the people who published it. It's a case where the Canadian, as we thought he was, investor was treated very poorly in an American court system. And so what's the remedy for that? In the end, he didn't get the remedy he wanted from ISDS, but where else does that person go, it seems to me? And on the reverse side, in Canada, when you have some of these decisions where municipalities or provinces, act arbitrarily, I have to say, as I cited before the work about Professor Armand Demetral, it's not clear to me that under Canadian law, any such investor has a remedy in those kind of cases. So that's, to me, why those are the paradigmatic cases where ISDS can be useful.
Thank you very much, Mr. Warner. Okay, thank you to our witnesses. We will allow you to leave, and thank you for the excellent information that you've given us. And we have some committee business that we will do. So if the witnesses could please exit the platform.
Thank you very much.
Okay, on to Monsieur Savard Tremblay. You have two motions. Do you want to speak to the first one?
Yes, could you please give me a moment so I can find the exact wording?
Oops, where am I? Yeah, there it is.
Just while Mr.
Great.
Savard Tremblay is looking there, apparently it's difficult to hear. So maybe look where your microphone is. There, that might be better.
Oui, alors.
Okay, so the first motion is as follows. That all documents, these are a routine motion, I would like to say, that all documents submitted for committee business that do not come from a federal department or that have not been translated by the Translation Bureau be sent for prior linguistic review by the Translation Bureau before being distributed to members. I think that you also have the English version of the motion that was sent to you.
Discussion with that motion. Okay, Ms. Bendayan and then Ms. Gray.
Thank you, Madam Chair. I believe that Ms. Gray had her hand up first. Obviously, up to you what order you would like to go in.
You're muted, Madam Chair.
Back on there again. Sorry, if we could just move on because I had allocated 10 minutes for these two motions.
Okay, in that case, I'll be very quick. Merci, Monsieur Savard Tremblay.
Thank you, Mr. Savard Tremblay. I agree with it. I think it's already the case in the practice, but I'm ready to vote for your motion so that it's formalized.
Okay. Thank you, Madam Chair. I think that we need to look at that this from a practical point of view and functional point of view may not always work to have everything go through the Translation Bureau. And I know it's been consistent at another committee to add in some other alternate ways of translation, and I believe this was has been approved of at least one other committee. And so if I could make the amendment to also add in MP offices and party research groups, if that would be the wording, because just to fully restrict it to the Translation Bureau itself, the timeline for turnaround may not always work, and there's fully capable people within the various political parties and at MP offices. Thank you, Madam Chair.
Thank you, Ms. Gray. Any further discussion? So we have the amendment that Ms. Gray has moved. Please raise your hands, all those in favor of the amendment.
Madam Chair, if I could just, okay. I apologize.
Okay, go ahead, Ms. Bendayan.
Moi, j'aimerais entendre Monsieur Savard Tremblay.
I would like to hear what Mr. Savard Tremblay thinks about this amendment. I don't think the amendment is necessary, but I would like to hear the person who actually tabled the motion. I'm just thinking about the ins and outs of this. Well, we could live with this amendment, but I think that the first motion was acceptable to. Ms. Gray, could you give us a precise formulation so that we can understand each word and how important they are for the motion?
Mr. Holbach?
Yeah, Chair, on the Special Committee for Canada, US, we actually put this amendment through. And what it did is it didn't jam the committee up, so we still couldn't proceed with doing things quickly, yet it still provided the resources that the Bloc Party or anybody speaking French required to get the appropriate documentation to them in a timely manner. So it was just a good compromise in that committee, and I think it worked well. It seems to be working well there, so it might be something that we can do here too.
Okay, thank you very much. I'm having some trouble with my translation today. So, Mr. Savard Tremblay, are we okay going forth with your motion as amended? Or did you want Ms. Gray to clarify?
Oui, j'aimerais bien avoir une précision au niveau du.
I would like the exact wording for the amendment, please.
Can you reiterate that?
Yes, I can. So it would add an MP's office and parties research group after the federal department. Alors, en français, que tous les documents présentés dans le cadre des travaux du comité et qui ne proviennent pas d'un ministère fédéral, d'un bureau de députés ou d'un bureau de recherche de parti, ou qui n'ont pas été traduits par le bureau de la traduction, soient préalablement soumis à une révision linguistique par le bureau de la traduction, etc.
Moi, ça me convient.
Okay, point of order, Madam Chair.
Did you have your hand up again?
Yeah,
Or
Chair,
yes.
could you read the whole motion now as amended? I think it'd be easier if you did that.
Okay, Madam Clerk.
That all documents submitted for committee business that do not come from a federal department, an MP's office, or a party research group, or that have not been translated by the Translation Bureau be sent for prior linguistic review by the Translation Bureau before being distributed to members.
Is everybody comfortable with that? All right, I'll just ask to please raise your hands, all those in favor of the motion as amended. Please raise your hands. Yeah, so you're fine, you carry. Okay, back to Mr. Savard Tremblay on your other motion.
Okay, that the clerk inform each witness who is to appear before the committee that the House Administration Support Team must conduct technical tests to check the connectivity and the equipment used to ensure the best possible sound quality, and that the chair advised the committee at the start of each meeting of any witness who did not perform the required technical tests.
Very much. Any discussion, Ms. Gray?
Thank you, Madam Chair, and we think that this is a good idea. It's good protocol.
Any further discussion? Not seeing any hands up. I assume it's Mr. John, you're okay? Okay, so all those in favor, please raise your hands. So it carries. All right, thank you all very much. Have a good week, and we'll connect Friday, if not before. Okay, thank you very much. Meeting adjourned. Thank you, Madam Clerk.
Thank you, Judy.